with estate planning, does divorce ever affect an active will?
Yeah.
Okay.
Yes, it does. Ontario law for succession law is quite an old law. There's laws that haven't changed in a really long time, but there's been a lot of change since the pandemic, actually. One of the things that changed is how the law treats married versus separated spouses. So prior to the pandemic, prior to 2021, if a couple was married, so that's the key. A married couple and common law couples have different rights. Okay, so I'm just still, even to this day, so I'm just addressing married couples right now. So in if there was a married couple prior to 2021, and let's say they had wills and then they were separating, ready to get divorced. In this case, the separated spouse had the same rights as the married spouse. So even though one of the spouses would go and have a will redone to remove the old spouse from the will, to remove the ex from the will, unfortunately, the law gave rights to the separated spouse as if they were married, which meant a married spouse is allowed to void their spouse's will. They're allowed to say, I am not taking under my gift under this will. I do not agree to this will. And then the will gets voided. I'm serious. So instead, what they get to elect under equalization, which means as if they were divorced. There were situations that didn't make any sense where couples were separated. They were in the process of getting divorced, but didn't get there. One of the people would have done a will to eliminate the ex-spouse from the will, but because they're still married, let's say that person would pass away, their spouse would say, I don't like that will. I still want to get half of everything as if we were divorced. And that would void the will. So what the Succession Law Reform Act did, there's an adjustment to it to adjust for separated spouses now. But spouses have to, and they're treated the same as if they were divorced. But in the case, there's certain rules. So they have to have this separated for at least 3 years. Or they have to have a separation agreement in place or a court order that deals with their affairs with respect to their separation. So there's conditions to it, but still, it's still better than before. So separated spouses, as long as there's something official saying that they're officially separated, they don't have the same rights as a married spouse. Thank God. On divorce, if the person doesn't change their will and then they get divorced, any gifts to their ex-spouse or any appointments in the will, such as executor appointments, are voided, as if the person predeceased them. So if I'm married and I get divorced and I have a will and I'm not changing my will, and then I pass away, anything I would have left to my spouse is voided. It's as if he predeceased me.
What if they are the executor? Then what happens?
Then they're not allowed to be an executor anymore. Their role, so they're removed as executor, even though the will says that they're an executor. The role of executor goes to the alternate executor that's appointed in the will. This is a really good gem. A will can still be a good will, valid will, even if there's no valid executor in the will.
Okay.
So somebody needs to step up and apply to be an executor. They will apply under special circumstances, but the will is still very much valid. And they can still get a certificate of appointment. So even if the person just named the spouse in their will and no alternate, that's still okay. The spouse is removed and somebody needs to step up, or the alternate that's appointed in the will just become the executor. And then I do the third piece. I practice real estate. And the reason I started practicing real estate is because my estates had a lot of real estate needs. So as an estate planning lawyer, you need to understand real estate. Most of my clients have property, so they need to be advised, and it's their most expensive asset in their estate. So they need to understand how the property will pass you know, how title is held, what it means to them, etc., and if they're okay with it. And same with the state administration, people passing away with real estate, owning properties. So that property eventually needs to be transferred to a beneficiary or sold. So anyway, that's how I started practicing real estate, to be a better estate lawyer. And then I just expanded my practice to regular purchases, sales, finances, transfers of title,